How do you analyze the statute of frauds on a contract's essay question? Well, step one, what is the statute of frauds? In short, you should think about the statute of frauds as merely an evidentiary requirement needed to prove that a contract existed between the parties. Imagine the following scenario. Let's say that you own a Lamborghini, a brand new Lamborghini, and I really want your Lamborghini, but of course, I can't afford it. I can't offer you a fair price for your Lamborghini. I don't have the money. So instead, I concoct a scheme, right? I have some knowledge of contract law, so I say, you know what? I'm gonna sue so-and-so for breach of contract. I'm gonna say that we had an oral contract for the purchase and sale of your Lamborghini for $1,000. So I go to court, I sue you for breach of contract, and I tell the court, guess what? So-and-so offered to sell me his Lamborghini orally for $1,000, and I accepted. We have offer, acceptance, the $1,000 is sufficient consideration. We have a traditional enforceable contract. So I'm gonna pay so-and-so $1,000. He has to provide me the Lamborghini. The court is gonna say, that's fine, Michael. If you did have a contract for the purchase and sale of the Lamborghini for $1,000, we'll enforce that. But you have to provide us proof that that contract existed. That contract falls under the statute of frauds. So in order to enforce it, you're gonna have to show us satisfaction of the statute of frauds, some sort of evidence that this contract existed. And generally, under the statute of frauds, that's gonna require me to produce a signed writing for the purchase and sale of the Lamborghini for $1,000, although in some instances we'll see that performance can also be sufficient evidence that the contract existed. Okay, but in short, that's why we have the statute of frauds. It's to prevent fraud. That's why we call it the statute of frauds. We want people, if they're going to come to court and sue for breach of contract, in certain instances, we're gonna say you have to provide proof that that contract existed. We're not gonna just let anybody come to court and say that they had all these oral agreements and contracts. It would be chaos, right? Anybody could come to court and claim anything. We had this oral agreement, that oral contract. The statute of frauds comes in to mitigate that and say, in some instances, we're gonna have to see proof that the contract you're claiming did indeed exist. Okay, so that's the idea behind the statute of frauds, but how do you actually analyze the statute of frauds on a contract's essay question? Well, your analysis is going to be two parts. Your first question is going to be whether the statute of frauds is triggered. Does this contract fall under the statute of frauds? And we'll learn that not every contract that's created does fall under the statute of frauds. You can have enforceable oral contracts, that's fine. Only a certain class or certain categories of contracts actually trigger the statute of frauds. And step one is going to be identifying whether the contract in your fact pattern does trigger the statute of frauds. Your next step, step number two, is going to be, okay, if the statute of frauds is triggered, was the statute of frauds satisfied? Is there sufficient evidence that the contract existed? And generally, like I said, that's going to require a signed writing, but in some cases we'll also see that performance, either complete performance or partial performance, can satisfy the statute of frauds. So that's everything we're going to talk about. And the main idea here, the main flow of the analysis is going to be if the statute of frauds is triggered and the statute of frauds is not satisfied, then that agreement is not enforceable in court, okay? Well, let's break down what types of contracts actually trigger the statute of frauds. We have an acronym for this, Mr. Sour, M-S-O-U-R. What does this stand for? The M stands for marriage. The S stands for suretyship. The O stands for the 1 year provision. 1 year provision. The U stands for UCC Goods contracts for $500 or more. And the R stands for real estate contracts, specifically promises to transfer or receive interests in real estate. But let's start with marriage. Wow, marriage is misspelled. There's an A right there. Marriage, right? So what we're talking about here is not the marriage contract itself, two people promising that they're going to marry each other. We're talking about contracts made in consideration of marriage. Primarily here, we're thinking prenups, premarital agreements, right? The prenup, that's gonna be the main thing. So if you have a prenup, that's going to trigger the statute of frauds. I actually recently read a case back from the 1800s where we had an uncle, I believe it was, promising to pay his niece $2,000 or something, $2,500 a month for every month that she stayed married to her husband. So in that case, that could also be a type of contract made in consideration of marriage. The key here for marriage is we're talking about generally prenups, premarital agreements are going to trigger the statute of frauds, but not the actual marriage contract itself. That is not going to trigger the statute of frauds. The promise between two people to marry each other does not trigger the statute of frauds, okay? Next we have suretyship contracts. Now I'm going to mispronounce that. For some reason I have a lot of trouble saying suretyship. I practiced saying it before this video, but I'm sure I will blow it as we go along here. But a suretyship contract has three parties, right? So you're going to have the surety, we'll say S. You're going to have the obligee, say O, and you're going to have the principal, we'll say P. Right, so in a suretyship contract, what we have, this is kind of like a guarantor contract if you've ever been a guarantor or a guarantee in a contract. But what we have here is going to be a surety promising an obligee to cover the debts of the principal if the principal fails to make timely payments. So this you could commonly see in a lease agreement, right? Let's say that my 18-year-old niece is leaving the nest, she's entering college, and she wants to rent an apartment. Well, she has no credit, no income coming in, so no apartment complex is going to give her a lease. She is not going to qualify. But what we can do is I can come in and say, hey, look, I want my niece to have an apartment, so I'll be a surety, and I'll promise the apartment complex, the obligee, to cover her rent, the principal. If she fails to make her rent payments on time, I'm guaranteeing her debt. Right, so I would be the surety, the apartment complex would be the obligee, and my niece would be the principal. That's going to be a suretyship contract, and that's going to trigger the statute of frauds. There is one exception here, the main purpose exception, main purpose exception, and that's going to be if the surety's main purpose for entering the contract is for his own economic benefit, that is not going to trigger the statute of fraud. So if my main purpose for giving this niece, for guaranteeing this contract for my niece, this lease, is for my own economic benefit. Let's say I'm setting her up an office in this apartment and I'm gonna work her 10 hours a day, you know, doing whatever, you know, in that case, I'm not giving her this out of the kindness of my heart. I'm doing it, the main purpose of this suretyship from my perspective as the surety is for my own economic benefit, not helping the principal, right? So in that case, that will not trigger the statute of frauds. That's called the main purpose exception. Next, we have the 1 year provision. This says that contracts that cannot be performed within 1 year from the day after the contract is made are going to trigger the statute of fraud. So basically, this is a 1 year timer. So when a contract is formed, from the next day, for 365 days, we have a timer, right? So we'll say formation right here, and then we have a little timeline. And right here, we have 365 days, right? So if the contract cannot be performed in this time, it can only be performed after this time, then that's going to trigger the statute of frauds. So let's say you hire me to be your law tutor for 366 days, right? that is going to trigger the statute of frauds. It's impossible for that contract to be performed in under 1 year, so that's going to trigger the statute of frauds. Now let's say that you hire me to be your law tutor for the rest of your life. Can that be performed in less than a year? Yes, you could die tomorrow, right? And that would be 1 day, or for the rest of my life, right? Anytime you see rest of someone's life, that's a trick, right? That can always be performed in less than a year because anyone can die at any time, right? And also tasks that seem like they would take longer than a year but could be performed in less than a year are also going to not trigger the statute of frauds. You would have a situation like a 5-man corporation promises someone that they're going to build them an exact replica of the Egyptian pyramids. It seems like that couldn't be performed in less than a year, but it is possible, right? Maybe they go out and hire people. We don't know what happens there. In that case, it is possible it could be performed in less than a year, so it doesn't trigger the statute of frauds. What we're looking for here is time, right? Generally in the contract for this to trigger the statute of frauds, we're looking for a 13-month lease, or the contract starts on this date and ends on this date, or it's a tutoring for 370 days, or a 13, 14, 15-month lease, right? Those types of things, it's actually impossible because there's a term requirement, right? So what you want to look at is actually the terms of the contract. And if there is a term requirement that's over a year, that's going to trigger the statute of frauds. But if there's nothing in it that explicitly says that this contract is going to last longer than a year, generally it's not going to trigger the statute of frauds. So you want to look for that express language in the contract. Next, we have UCC Goods contracts for $500 or more. This is very straightforward. I offer to sell you 100 dry erase markers for $600. That's going to trigger the statute of frauds. Some jurisdictions have raised this requirement to $5,000. Don't worry about that on a contracts essay. Your grader is going to want to see the requirement at $500 unless the fact pattern tells you otherwise. The rule should be $500. So any UCC goods contract for more than $500, that's going to trigger the statute of frauds. Finally, again, real estate, very straightforward. Any contract or promise to transfer or receive an interest in real estate is going to trigger the statute of frauds. So you're thinking that could be mortgages, liens, any type of interest in real property. That's going to trigger the statute of frauds, okay? So that's your 5 big triggers. We have M-SOUR, marriage, suretyship, 1-year provision, UCC goods contracts for $500 or more, and real estate contracts. So if we have a contract that triggers any of these events, right, any of these things, then we know step 1, statute of frauds is triggered. Step 2, the statute of frauds now has to be satisfied. We'll call this satisfaction. Satisfaction. Right, and there's 2 primary ways that you can satisfy the statute of frauds. We'll just put a little A here, B here. That's going to be the writing requirement. So we have writing, and also we have performance. Performance. So these are the 2 main ways that you can satisfy the statute of frauds. You're either going to have to produce a writing that is signed by the party to be charged, or you're going to have to show performance. So let's talk about the writing requirement first. Okay, so generally the writing requirement is going to need 3, well, depending on how you break this down, let's just say that the writing requirement is going to need to be, first of all, number 1, obviously it has to be in writing. It has to be signed, right? That's your first big requirement. It has to be signed by the party against whom enforcement is sought. Usually that's the defendant, right? So number 1, it has to be signed not by both parties. In my Lamborghini example, it doesn't matter if I've signed the agreement. It's all about whether you sign the agreement, right? Because think about it. Statute of frauds is all about preventing fraud. I could easily produce a fake contract and sign it myself. We don't care about that. We want to see that the party against whom enforcement is sought has signed it, right? So we have to have that as a signature requirement. Also, the essential terms are going to have to be there. So I'll just put essential terms, right? That's going to be your next big requirement. And the essential terms are going to vary a little bit between UCC contracts and common law contracts. Under the UCC, the price term is not usually going to be required. It's just going to be parties, subject matter, and quantity. Under the common law, you are going to need that price term. So parties, subject matter, quantity, and the price term. So that's generally going to be your essential terms. And important to recognize with essential terms in a writing, they can be included in separate writings so long as the separate writings reference each other. So if there's references made, that's fine. Okay, so those are your two main requirements: as signed by the party against whom enforcement is sought, and that you have those essential terms. Also, an important thing to recognize here too is what happens if the writing is destroyed. If you are going to be allowed in court to put on evidence, oral testimony, that the writing at one time did exist and met these requirements, even if it's lost or destroyed. If you can do that, if you can prove that you did have a signed writing that met all the requirements at some point in time with oral testimony or whatever evidence, that's going to be enough to satisfy the statute of frauds. Okay, so number one, the satisfaction can be a signed writing that has all the essential terms in it, right? Okay? Now the next thing is performance. Sometimes we're gonna say, okay, even if you didn't have a signed writing, performance, whether it's full performance or partial performance in certain situations, can still satisfy the statute of frauds. We're gonna say it's still sufficient evidence. Even though you didn't have a signed writing, because of this performance, we're going to now believe you. We think that that performance shows sufficient evidence that the contract existed. The main things that you're going to want to think about here are services contracts. So I'll just write, maybe right here, services contracts, goods contracts, and real estate contracts. So these are going to be your big three to think about in terms of how performance works. So services is really easy. If you have a service contract, you have to show full performance by either side in order for that to satisfy the statute of frauds. So if I'm, whatever, it could be for, I'm offering you any type of service contract, right, that triggers the statute of frauds. So we'll stick to the law tutor example, right? You offer, or I offer to be your law tutor for 2 years. You accept. When you, and let's say it's all oral, when you hand me that money, you've satisfied full performance of your obligation. Say it's an upfront deal, you pay me the 2 years up front. That full performance on your side can satisfy the statute of frauds if you can show that you did pay. Or if I do tutor you for 2 years, that would be full performance on my side. That's going to be enough to satisfy the statute of frauds for services contracts. So even though we didn't have a writing and the statute of frauds was triggered, because we have full performance by a party, that can satisfy the statute of frauds under services contracts. Next, we have goods contracts. Goods contracts, partial performance can still satisfy the statute of frauds. So this is a little bit different than goods, or from services contract. Under a goods contract, where the UCC is triggered, partial performance will work for as many goods are delivered and accepted, right? So let's say that we have a contract that I'm going to sell you 100 dry erase markers for $1,000. So we have a UCC goods contract that's over $500. So the statute of frauds is triggered. We have to satisfy that. But let's say that our agreement was oral. Okay, well, when I deliver you 50 of the dry erase markers, half of the performance, 50 of the 100s, I deliver those and you accept those markers, we have an enforceable contract for the quantity that is delivered and accepted. Now, the remaining 50 that are promised are not going to be enforceable, but we have a contract in as much as the amount of goods that are delivered and accepted. So that part, the 50 markers that have been delivered and accepted under the contract is going to be enforceable. We have partial performance for the amount delivered and accepted, means that the statute of frauds is triggered, it's satisfied for the amount delivered and accepted, so it's enforceable up to the amount delivered and accepted. The main exception here, or another thing to think about with goods contracts that you sometimes see tested, would be custom-made goods. Imagine a contract to manufacture, I don't know, monogrammed shirts, right? Because that's custom and it's monogrammed and it's so specific, we're going to say that once the manufacturer makes a substantial beginning towards manufacturing those custom-made goods, the statute of frauds is satisfied, right? If it is triggered, we're gonna say that a substantial beginning towards a manufacturing of custom-made goods satisfies the statute of frauds. So we're not even worried about the amount that's delivered and accepted. It's going to be satisfied from the time manufacturing begins, okay? So just another note there on goods, but that's services and goods contracts. How? So services, remember, full performance is required to satisfy the statute of frauds. Goods contracts, we can have part performance, but it's usually only for the amount delivered and accepted. And finally, we have real estate. Real estate is interesting because you have a situation where we say, okay, generally real estate contracts have to be in writing, right? But we have three factors, and if any two of the three factors are satisfied, we're going to say that that is sufficient evidence that a contract existed. That's going to be possession, payment, and repairs. If any of those two of those three things happens, that's going to satisfy the statute of frauds. So if somebody takes possession of real estate and makes repairs on that real estate, even though they didn't have a signed writing, we're gonna say that's evidence enough that the contract existed. If they take possession and make payment, or if they make payment and have repairs done, right? Any two of the three, possession of the real estate, payment towards, it can be partial or full payment towards the real estate contract, or repairs made to the land or the real estate. Any two of those three, that performance is going to satisfy the statute of fraud. So for real estate contracts, you can have a signed writing that identifies all the essential terms, or two of the three, performance, possession, payment, or repairs. Okay guys, that's everything you need to know for the statute of frauds. Remember, step one is the statute of frauds triggered? If it is the statute of frauds satisfied? If it is, you're good, you have an enforceable contract. If it's triggered, if the statute of frauds is triggered and not satisfied, then the contract is unenforceable. That's how a contract law statute of fraud analysis is going to break down. With that, I'll leave you all to it. I wish you all the absolute best. I hope this video was helpful, and I'll see you at our next video.